How long is the statute of limitations for reporting criminal sexual conduct? Well, in Minnesota, the answer is actually fairly complicated. A statute of limitations means how long the prosecution has to charge you with a crime after a crime has been committed or been reported, depending on the statute of limitations. So, for example, let's say today is January 1st, 2020, and a crime occurred today. And let's say that the statute of limitations for this particular crime is 3 years from the date of commission of the crime. That would mean that the prosecution would have 3 years from today to charge the crime out. If they have not charged you within that 3 years, and they charge you 3 years and 1 day later, meaning January 2nd, 2023, they've missed the statute of limitations by 1 day. They've gone beyond it by 1 day, and you can raise that as a defense and have your case potentially thrown out for a violation of the statute of limitations. So that's how the statute of limitations works. However, in criminal sexual conduct cases in Minnesota, the law is a little more complicated on statute of limitations than it is for most other crimes. So the Minnesota statute that governs the statute of limitations for criminal sexual conduct cases has several subparts, and they really break it up by whether evidence was collected within a certain time, as well as the age of the alleged victim at the time of the alleged crime. So I'll go bit by bit through those. There are some instances in Minnesota where there is no statute of limitations. So for example, in a first-degree murder case, premeditated murder, there's no statute of limitations for that. The government can charge you 50 years after the alleged crime if they want. However long they want to take before they charge you, they can do that. And that is the same situation for some types of criminal sexual conduct. So in Minnesota, we have 5 degrees of criminal sexual conduct. The first degree is the most serious, and the 5th degree is the least serious of all of those, all right? For the statute of limitations, in a 1st through 4th degree case, so 1st, 2nd, 3rd, and 4th degree, if the alleged victim or the accuser was under age 18 at the time the alleged offense was committed, then the prosecutors have an option. They have 9 years to charge you from the date of the alleged offense date, or 3 years after it was first reported to law enforcement, which could very well be longer than 9 years. So this is how this works. Let's say that an alleged offense happened on January 1st, 2010, and the accuser is under age 18. So let's say he or she is age 16 at the time of the alleged offense back in January 1st of 2010. The government has to charge you either within 9 years of that date, so January 1st, 2019, or if it wasn't reported that whole time and now this person, it's 2020, we're beyond the 9 years, and now May 31st of 2020, the accuser first time reports this to law enforcement. Now they get 3 years from that date, May 31st of 2020, to prosecute you. So that would mean they'd have until May 31st of 2023, which as you can tell is, if my math is right here, 13 and a half years before they charge you. So they either get 9 years from the date of the alleged offense or 3 years after it's reported to law enforcement, whichever is longer. So that's how that works if the accuser is under age 18. But there's even an exception to that. If at the time of a report, physical evidence is collected. So let's say it's not reported to law enforcement. Let's say that somebody goes in and they either save, well, typically what would happen would be there'd be a sex assault exam. For whatever reason, let's say it's not reported to law enforcement, but physical evidence is collected. They don't know who did this yet, but physical evidence is collected from, like say, a sex assault exam at the hospital. And DNA is collected, and they're able to determine it's from an opposite sex DNA, for example. It doesn't have to be opposite sex, but I'm just giving an example. And they don't know who the perpetrator is, right? In that situation where DNA evidence is collected and the accuser or alleged victim is under 18 years of age, then there's no statute of limitations. So I'll give you an example again. Let's say someone's a victim of a sex assault and they're 16 years old, so they're under 18, all right? And they go to the hospital, they get a sex assault exam, DNA evidence is collected, from the perpetrator, but they don't know who the perpetrator is, for example. All right, now 15 years go by, and then later in time, they're able to use this DNA to find out who this was. Maybe there's a match in the database later or something like that. There's no statute of limitations there because the DNA evidence was collected from the scene, basically, or at or near the time of the alleged crime. But there's another exception. If DNA evidence is not collected and preserved, and the alleged victim is 18 years or older at the time of the alleged offense, then the prosecutors have to charge you within 9 years of the date of the alleged offense. They can't wait 9.5 years. They can't wait even 9 years and 1 extra day. So they've got 9 years if the accuser is 18 or over, and if DNA evidence was not collected at the time. It's important to note that that DNA evidence has to be not only collected at the time, but it has to be preserved for that amount of time as well. They can't collect the evidence, test it, and then get rid of it. They've got to preserve it as well. So to recap on that, if a sex assault or an alleged sex assault occurs and DNA evidence is collected and preserved, and the prosecution has an unlimited amount of time to charge a sex offense for a 1st through 4th degree criminal sexual conduct. If the evidence is not collected and preserved and the accuser is age 18 or more at the time of the alleged offense, then the prosecutors get 9 years to charge a crime out. Now, there's one other exception, and that's for 5th degree, which under Minnesota law is a gross misdemeanor. All the others are felony. But a 5th degree criminal sexual conduct, they get 3 years to charge the crime out. That's the limit on all 5th degree cases in Minnesota. So obviously some parts about the problems of statute of limitations are the reason that statute of limitations exist is because evidence can go away after a certain amount of time, and somebody who's defending against an allegation may not be able to recall anymore where they were. They may not have an alibi witness anymore because people can die, they can move away, records can be destroyed, all of those sorts of things. So that's why statute of limitations exist as a matter of due process for accused people, because we value the idea that people ought to be able to defend themselves against such charges, and with the longer passage of time, that can deprive a defendant and their defense team from putting forth the defense and showing facts, even though the defense doesn't have to show any facts in a trial. Obviously, it can be helpful when we can do that. And so statute of limitations exists in 99% of crimes out there, and for good reason. However, over the years, what the Minnesota legislature has done is expand statute of limitations and afford more opportunity and longer amounts of time for the prosecution to charge crimes out. So that's the current state of the law on statute of limitations. These have undergone several amendments or changes to the law in the last 15 years, and that may continue into the future as well. So this information is good for now, but you should always check with, of course, a lawyer when you're charged with the crime, especially if it's an older allegation. One of the things we want to do first is determine whether or not the statute of limitations applies and if you have a defense to that. Because you might think, well, once the statute of limitations is reached and expired, they can't charge me anymore. That's not true. I've had plenty of cases from all different kinds of crimes where the prosecution has still charged people even though the statute of limitations has expired. A good defense attorney will take a look at the statute of limitations and make sure that you're not improperly charged in a situation like that. If you have more questions about this, you can always contact me. My name is Ryan Pasiga. You can find me at arrestedmn.com. You can call me at 612-339-5844, and you can click my link on the website below Of course, you can always go to the support page I have on Facebook. This support page is for people that are accused of sex assault crimes and their families, and hopefully put together some resources for them as they're going through these times as well. Thank you.